ladies and gentlemen. Welcome to another edition of Oval Trade Talk. I am joined today by Mr. Simon Lester, who's a trade policy analyst at Cato's Herbert A. Stifel Center for Trade Policy Studies. His research focuses on WTO disputes, regional trade agreements, disguised protectionism, and the history of international trade law. Before joining Cato Institute, he worked as a trade law practitioner for a Washington, D.C. law firm, and also as a legal affairs officer at the appellate body secretariat of the World Trade Organization. In 2001, he founded the international trade law website, worldtradelaw.net, and has published widely in peer-reviewed journals such as the Stanford Journal of International Law and the George Washington International Law Review. In addition, he also teaches courses on international trade law at American University's Washington College of Law and University of Michigan Law School. Issues on today's interview. 3 questions on mega regional trade deals, coupled with a few on the future of WTO and what is happening within the WTO. So to start the interview, I would like to focus on reports that have surfaced, which are saying that the US and Switzerland are planning to build a lobby at the 10th Ministerial Conference, which is going to push for ending the moratorium on non-violation complaints under the TRIPS. This would mean that they would be able to bring patent disputes to the DSB for provisions which may not actually violate the TRIPS, but still lead to nullification or impairment of benefits. Now, Professor Susie Frankel has argued that if the US uses pressure tactics through non-violation complaints and brings a dispute against countries like India, a similar strategy could be adopted by countries like India for pressuring the US to change its FTA IP chapters, which are TRIPS Plus, claiming that there has been an erosion of expected benefits. So my question to you is twofold in this regard. How likely do you think is the move to succeed at the Ministerial Conference in Nairobi? And second, if it ever succeeds, are we looking at opening a Pandora's box?
It's a fascinating issue. I think I have some thoughts on it. I don't know if I can answer all your questions about it. In terms of the politics of it, how likely is the U.S. and Switzerland push to succeed? How likely is that this will succeed? I really can't speak to it. I mean, I'm aware that there's some resistance, and then there are a number of countries who have sort of joined up to fight against this. And how does this battle play out at the WTO? I don't know. I can't predict it. They can't seem to get anything done there. It's sort of hard to imagine how this gets done one way or the other. I mean, don't we just kind of perpetuate the status quo because there just seems to be clear disagreement? But I don't know. I mean, if they can put together a whole package of issues where they reach agreement, can they find a middle ground on this one? Perhaps. It doesn't seem likely at this point. I think that the substance is where I have a little more to say. Maybe that's a little more helpful because I just can't predict the politics. Non-violation is a fascinating issue. The first WTO case I ever worked on as a private lawyer was the Japan film case. So I jumped right in. That was the first issue I ever dealt with, and so I thought a fair amount about it. I don't consider myself the leading thinker on it, but I have thought about it, and I've researched the origins of it, and it's really kind of interesting, how this provision arises. So back in the late 1920s, early 1930s, governments were trying to deal with the problem of indirect protectionism, and they knew they could reduce tariffs, but they were worried about domestic regulations that could interfere in some way with trade, and so. Some people who were thinking about this came up with this idea of the equitable treatment clause, which is basically saying, look, you're doing something that's not fair, and we should be able to consult and talk about it. And over a period of a couple of years, this evolved into the nullification or impairment language that we see today. My view of non-violation is that when they were first trying to figure out what to do about domestic regulations that could take the place of tariffs that had been reduced, The problem they had was that there was no regulation of these other measures. There was no national treatment clause. There were no subsidies provisions. So they thought, well, let's just come up with this general concept to deal with everything. In the meantime, however, they also came up with very specific rules to deal with particular problems. So they came up with a national treatment clause, and they started working on subsidies. And as time progressed, when we get to the Tokyo round and the Uruguay round, we now have strong disciplines on subsidies, and we have the TBT agreement. We have all these other things. And so it seems to me that the problem that the non-violation remedy was designed to deal with just doesn't exist anymore. There aren't regulations that are unexpectedly going to interfere with trade, because we set out very clearly what's prohibited and what's not prohibited. So that's some general thoughts about non-violation. Now, we're talking here about the specific context of the TRIPS agreement. Is that somehow different? Is there something special about the TRIPS agreement that guides us in a different direction than where we would be normally? It's not clear to me that there is. There's been plenty of discussion about how TRIPS fits within the global trade rules more generally, and many people suggested it doesn't fit very well in there, and I'm sort of sympathetic to that. But is there some argument for doing something different with non-violation than we do with regular trade in goods or services? And my view is actually that it's not clear to me why we need non-violation in any context. But we're only talking about TRIPS right now. No one's calling for a rethinking of non-violation in the trade in goods or trade in services context. So what do we do about TRIPS? I just had a conversation with somebody about this, arguing for why we do need non-violation in the TRIPS agreement and what are the potential problems there. I just don't find it that convincing. I mean, we've got this detailed set of rules about protection of intellectual property, and it seems to me that we've laid out very clearly what you have to do, what you can't do, and this problem of some unexpected measure that we need to challenge even though it doesn't violate, it doesn't strike me as a real one or a compelling one. So I just don't see the need for it. Now, you've got this question of, well, the U.S. and Switzerland want to have it in there, and they want to use it to push for stronger intellectual property protection. Well, what if developing countries said, well, if it's in there, we're going to use it too, and let's challenge some of the things the U.S. is doing. That's certainly, all of that's plausible. I mean, this is the kind of thing you can imagine it happening. On the other hand, I mean, there's plenty of WTO obligations where you can imagine the cases, but they really haven't come yet. And so I can definitely imagine that we end the moratorium and we have a non-violation remedy for intellectual property, but nobody brings any cases. I mean, what cases are we talking about bringing? It's just not clear to me. The U.S. and Switzerland want to have this in there, but why? What cases are they thinking about? And then on the flip side of that, yes, India potentially could say, well, we don't like what the U.S. is doing in some of their FTAs, and we want to see if we can use this non-violation remedy to deal with that, to address that. It's all plausible. It may just be, sort of like the Airbus Boeing subsidies. I mean, or cases like that where these things just, both go, these things go on, governments act in certain ways and other governments are concerned about them, but nobody brings a case. But as soon as somebody brings one case, the other government brings a case against them. So it may be that we could end the non-violation moratorium. 10 years from now, the U.S. brings a case, and then in response to that, India brings a case against the U.S. All of that's plausible, but it's very, very hard to predict. And so, going back to predictions, I mean, it seems it's not clear to me how the U.S. and Switzerland are going to get this moratorium ended. I mean, what are they going to? Is there any deal that's plausible in general? And could an end to the moratorium be part of it? I mean, anything's possible. I don't see a pathway to it. So, it may be none of this really happens. If it does happen, though, then we get into, well, let's wait and see. Or does the U.S. industry have a case that it's pushing for? It may take a few years to work its way out. So those are my thoughts on it. I mean, it's a fascinating area to watch. I've been meaning to do a blog post on this non-violation issue in the TRIPS agreement. I haven't gotten to it. I have one in mind. So I love the question. I hope I gave some useful thoughts, but a lot of it for me is just let's wait and see. I mean, I have views on what we should do here. I'm not sure who to, I'm not sure who all the players are and who to make the case to, but I will probably blog about it and at least, hint at the idea that I'm not really sure we need any of this, and I'm not really sure why we need it in the TRIPS agreement in particular.
Moving on, Professor, from TRIPS, I want to move on to the recent WikiLeaks on chapters of the Trade and Services Agreement. What this has revealed is that there is going to be a massive deregulation of the services sector. And in particular, there is a provision on competitive neutrality, which envisages that government-provided services could be deemed unfair trade practices if they disadvantage a private provider. My question to you is that at a time when the world is still recovering from a crisis caused by financial deregulation, do you think it's prudent to pursue an agreement which severely curtails a government's right to regulate, let's say, the financial services industry?
Let me start by saying, and I won't focus too much on this, but let me start by saying I am in general a big fan of deregulation and privatization. However, in the trade context, I have never been one to push for more deregulation and privatization through trade agreements, or very limited anyway. So, so although I support deregulation and privatization, I don't really think trade agreements are the best way to achieve that. I think it has to be done domestically. Now, talking about TISA, I think the WikiLeaks documents, the way they've been interpreted and discussed by the WikiLeaks people and other trade critics, I think they misunderstand how services rules work. Now, I understand that if you only look at the legal texts, you could think it means more than it does. In the services context, what everybody has to understand is you only commit to specific things that you set out in a schedule. So sector by sector in services, so finance, computers, construction, all of these different sectors, governments make commitments to, or can make commitments to liberalize. But they can also, but there's no general obligation to liberalize every services sector through the TISA or through the GATS or through any other services chapter. So you don't know what anybody's committed to until you see the scheduled commitments on services. So, these legal texts are interesting. As a lawyer, I love thinking about what they might mean, but it doesn't mean anything until somebody's actually committed to open up a particular sector. So we don't know what anybody's promised in financial services. The TISA discussions are still early on. I don't know what anyone's committed to, and TPP is something that's further along, and if that ever gets done, we'll have a sense of what kinds of things governments are willing to commit to these days. But it really may not be all that much. And if you look through the GATS, there's just plenty of sectors where you see governments just haven't committed to do anything. If they haven't committed, they don't have to do anything. It doesn't matter what the legal obligations are. If you haven't promised to open this sector, you don't have to do anything. Now, in terms of the substantive commitments, I think we also need to distinguish between two types of commitments. And so I think TISA will do something similar. I'm pretty sure it will. But if you look at the GATS, there's two kinds of commitments you can make, two main kinds: national treatment and market access. With national treatment, you're really just promising not to discriminate against foreigners. You're not saying we will deregulate and privatize. You're saying we're going to treat domestic service providers just like foreign service providers. And I think that should be a lot less scary to people. That doesn't mean you're going to privatize everything. Now, the market access commitments are much more confusing and hard to figure out. And I do agree that there are some commitments there that could be interpreted to mean that you actually have to privatize or deregulate. That there aren't cases that say that. There aren't that many GATS cases in general, and the ones that there are mostly focus on non-discrimination, I would argue, although, it gets complicated. It's more than we can deal with here, I think. So for the WikiLeaks people and those who read the WikiLeaks documents and get all worked up, I think they're exaggerating it. I think the worry here is just not as great as they think. I do agree that, in theory, a government might commit to deregulate to a limited extent or even to privatize something. That can happen, but I don't think it's going to be very significant. And the idea of the idea of trade disputes where about a government's actions that are not discriminatory, I don't know. It's kind of far-fetched. It may not be much of a real threat. But I don't mean to say it could never happen, but practically speaking, I don't think this is a likely scenario. And we really do have to wait to see what are these commitments? What has everybody committed to? And until we see that, I don't think there's enough to get worked up about. I think it's worth monitoring for those who are concerned. I think it's worth following. I would just, caution on the rhetoric and wait and see until there's an actual, TISA, text with all the scheduled commitments. And if for those who are monitoring this, I'd say look first at the TPP when that comes out, or look at the CETA, Canada-EU trade agreement, or look at the Australia-China free trade agreement. I mean, these are examples of where governments are making real service commitments, and to see what's actually in a trade agreement related to services regulation, look there. Don't get too worked up about TISA yet, but yeah, keep an eye on it if you're concerned about these things.
So, do you think it's in the interest of more countries to become part of the negotiations for TISA right now? Particularly, I speak about India, which has a very significant services industry, which has come up post-liberalization. And India tried to signal a counter move in the sense that they wanted a separate negotiations for services sector according to their terms and condition, and it signaled that in 2005, followed in 2008. But since then, it's been in a state of ambivalence because it does not know whether it wants to be part of TISA or whether it wants to propose something which rivals the TISA. Do you think the TISA provides the room for all the countries to come together and negotiate this?
I think it does, and I'm a big fan of services liberalization. I think there are great opportunities there for producers on both sides, and then the real benefit is to consumers. So, I mean, two issues I've written about are education services and online medical services. I mean, you can do things online that you never used to be able to do, and that gives opportunities to people all over the world to offer their services to a global market. And I would think India would be very well situated to do this in a number of service sectors. I like the idea of multilateral negotiations, and TISA is, sort of, it's not the whole world, but it's a large number of companies. I would love to see more countries. I'd love to see more involved. It gets difficult the more countries you have in there. To me, this is just all about how seriously we take liberalization, and if the U.S. and the EU and China and others really want to liberalize in this area, I think this is a great opportunity to do it. But they have to be committed to opening up their market to foreign service providers. If they're not, it's not going to work. But if they are, this is a great place to do it. I'd love to see as many countries as possible on board. I mean, TISA, I think, because it's so focused on services and it doesn't bring in issues like intellectual property or investor state or labor and environment, I mean, it really has the potential to be a purer, trade liberalization negotiation. We all have to agree to open up our markets, and we all get access to other people's markets. And if people, if people are enthusiastic about that and buy into the concept, I think we can achieve a lot. I think India can achieve a lot. I think everybody can achieve a lot. And yeah, India in particular, from what I hear, has some service sectors, just are very competitive. And I mean, I know India is a big market of 1 billion people or so, but there's 7 billion people around the world. So why not try to sell your services to the rest of the world as well?
I'd like to take you to now a question on the dispute settlement body and how its performance has been. As you know, this year marks 20 years of the WTO and 20 years of the dispute settlement body. According to you, has the DSB served its mandate effectively thus far? And what are some changes that you would like to see the way the dispute settlement body approaches disputes?
I think the dispute settlement body has been very effective. I think, you're always going to see criticism of courts. Domestic courts get criticized, certainly here in the U.S., and I assume in the rest of the world as well. So, you'll see criticisms of this panel report or this appellate body report or the appellate body's approach here. But overall, I mean, these are well-written decisions. They're well-reasoned. Governments take them seriously. We don't have 100% compliance, but people generally comply. The task of panels in the appellate body has been a very difficult one. As we all know, trade legal texts are often a matter of compromise. So it's not easy to interpret them. I mean, the negotiators were intentionally trying to make it vague, and so you've given the dispute settlement organs of the WTO just a difficult task. I think they've done fairly well with it, and they have a high degree of respect. In terms of particular suggestions for reform, one answer to that might be, well, if it ain't broke, don't fix it. It's going pretty well. I don't know that we need to sort of let's overhaul the whole thing. There are certainly tweaks you can make here and there, and they've been doing dispute settlement reviews for many years now, and say people make suggestions about the role of third parties, and all of that's fine. I mean, I think it's I personally think it would actually be useful to, outside of the context of the Doha round or trade facilitation, all these other things, just sit down and say, all right, let's come up with some good tweaks to dispute settlement given our experience, just sort of as a separate agreement. I think maybe that could be done. I mean, we might have to keep out the most controversial issues, but I think there are probably some small ones we can fit in there. In terms of broader reform, I want to raise one that I think is somewhat controversial for some people, but I mean, I think it is important to talk about the role of the Secretariat and the way panelists in particular are chosen. And I think there are some good arguments that for a permanent panel body to make this just seem more typically judicial and more credible, rather than sort of having part-time people, people who might have a full-time job but then have to go work on a case. And the result of that is that you end up with a strong role for the Secretariat. Now, this hasn't been too controversial, and I'm glad. I mean, I don't want to bring controversy to the WTO, but I do see the possibility there for criticism of, well, wait, who's writing these decisions? Shouldn't we have permanent judges here with their own clerks? So, again, I'm hesitant to sort of blow up the whole system when it's going so well, but I do think there's room for a real kind of rethinking about what the international trade courts should look like. Should we shift them? I mean, because the appellate body has a permanent set of appellate body members. Do we want to think of something similar for panelists? Do we want panelists for the appellate body to have their own clerks? So I think that's room for some thought and discussion. But I mean, I also recognize that would be, that would upset the way things have been done for a long time, and it may not be easy to achieve. But if we're looking for areas of significant reform, that might be one to keep in mind for the day 10 years from now. If you look at investor-state arbitration and how controversial that's been, and part of that is the way arbitrators are chosen, if we want to avoid that, that criticism later on, maybe we want to think now about how to make this look more credible, more judicial.
Move on to the African tripartite free trade area that's been proposed between the East African community, the Southern African Development Community, and the COMESA. Now, this free trade area is going to cover 26 countries ranging from Egypt to South Africa, and covers a population of 625 million people with an aggregate GDP of $1 trillion. According to you, what is the significance of this development for the African economy in particular, and the world economy in general? And the second part of my question is that, do you feel that we are moving towards an FTA, RTA dominated world trade order where the role of WTO will be severely diminished?
Those are great questions. I'm definitely a strong multilateralist, and I always favor liberalizing as broadly as possible at the WTO. At the same time, I recognize there are certain regions that have historic ties, and Europe is a prime example. We've got NAFTA, we've got ASEAN. I mean, there's areas of the world where countries that are closely linked by geography have done more intensive liberalization amongst each other, with each other, and I don't object to that. I think it can be very good, and to hear that Africa is doing something like that, I think that could be very valuable. I'm not an expert on sort of Africa and African integration. I know there are a number of smaller kind of trade investment pacts between different countries. To have a sort of broader one, I think that could be very good for Africa. I do think that there is a concern more generally about just regionalism detract from the WTO. And I think that multilateralism and regionalism can work together. I think you could have multiple blocks like NAFTA and the EU and an African trade treaty. And it wouldn't undermine the WTO. It would simply be that, well, of these similar countries who are close, regional, close geographic ties, maybe cultural ties, they can go a little further than we can possibly imagine at the multilateral level. I get more concerned about agreements like the TPP, the Trans-Pacific Partnership, which doesn't seem that regionally focused. I mean, yes, they're all sort of in the same region, but it's really spread out, and you haven't included everybody, and I'm not sure what the ties are between these countries. So something like that worries me more in terms of undermining the WTO. My feeling about it is, regardless of whether it's a regional African trade treaty or the TPP, I feel like these all need to be integrated a little better into the WTO, sort of have the WTO sort of monitoring and administering them. If there are disputes in these bilateral, regional, plurilateral trade agreements, maybe they could use the WTO dispute settlement system. The general monitoring of these bilateral regional trade agreements at the WTO has been pretty lax. There is a process for looking at them, but the WTO just really hasn't had the authority to step in and say, well, you haven't complied with the rules we set out for these agreements. I mean, these are allowed under pursuant to the GATT and the GATS, but maybe there should be just a little closer monitoring. So my thought, and I haven't really developed this, is that the WTO Secretariat just could be the central place where all trade agreements are sort of housed and administered. And so NAFTA, the EU is maybe more of a political agreement at this point, but NAFTA, Mercosur, and any African agreement, I mean, this could all be sort of handled and administered and monitored within the WTO. So I think there's a way. I mean, we've seen this proliferation of these agreements in the last 15 years, and it seems absurd at this point. We just keep signing these agreements, and then it's just hard to keep up with them. And are there disputes? Are they having meetings? Like, what's going on with these things? Are they just forgotten about? Because beyond the tariff reductions, there are very detailed legal obligations in a variety of policy areas. Shouldn't somebody be keeping track of this? I mean, it's fine. I mean, maybe those in the scholarly world or other places can do that, but it does seem like it would be useful to have a central place to sort of administer all these things. So, to sum up, yeah, I think it's great for African countries to pursue these types of things. I worry a little bit about how it undermines the WTO. And I think maybe there's a better role for the WTO to play here, and maybe that's part of the answer to all the worrying about whether the WTO really functions now. Can we actually negotiate anything? Is, well, maybe the WTO can sort of keep track of all these things we actually are negotiating, and sort of create a formal role for the WTO in the area of regional bilateral trade agreements.
Coming to TPP, Professor Lester, do you see the coming of TPP with a sense of foreboding, especially for the developing economies? Because it's been suggested in various literature that it's going to result in certain shocks for developing economies because they will not be able to match up to the standards that are being proposed under the TPP. Let's take India as an example again over here. Now, India has been slowly integrating herself in the global value chains, but the execution of TPP, some scholars have argued, is going to diminish that advantage that India has been exercising currently with respect to the global value chains because of the standards that may be established under the TPP. What do you think should be a counter strategy for a country like India or for a country like China to sustain the shocks of a successful TPP?
Yeah. It's a hard question. First thing, let's just point out, I mean, the TPP may just fail on its own. So maybe there's nothing to worry about for India or other countries. So let's see what happens with the TPP. In terms of, okay, let's say there is a TPP and it sets certain standards and makes it harder for India and China to trade with the US or other countries that are part of the TPP. Well, maybe it depends in part what standards we're talking about. I mean, we're talking about labor and environment standards. Do India and China, are they not in compliance with whatever these standards are that the U.S. is proposing? Well, maybe it's not that hard to comply with them. Maybe there are sort of tweaks here and there that you could actually comply with them. I mean, it's not clear to me we're talking about excessive standards that are completely impossible to comply with. I mean, as I understand it, I'm not an expert on this, there are ILO conventions the U.S. hasn't even signed up to. So I don't know if our standards are impossible to meet, or the ones that the U.S. is promoting in the TPP. So maybe it's possible just to comply. Aside from that, I mean, China has signed a number of trade agreements, and they just haven't put labor and environment standards in there. I'm trying to think in terms of India and its strategy here. Another strategy, I think, maybe just to sign on to them and worry about it later. Now, there are problems with that. I recognize there are flaws in that, and you can see that in the context of investment treaties. Countries maybe signed up to things that they didn't worry about, and now they're worrying about them as they get sued. But if you think about labor and environment provisions in U.S. trade agreements, we've got them in a number of agreements now, but how often does the U.S. try to enforce them? The best of my knowledge, there's one case going on under CAFTA where the U.S. is complaining about Guatemala's failure to enforce its labor laws, but that's it. So, maybe you just sign on to these things and worry about the litigation when it happens, because it's really not likely to be that big a deal. And maybe when it does come, you can just make small tweaks. So I guess my feeling about it would be, if you're India or China and you have this general concern, I would try to pinpoint it. What exact standards are you talking about that you think you can't meet? Is it possible to actually meet them? And if you can't, what are your chances of this actually coming to litigation and having any consequences for you? Because it may not be as big a deal as you think. Aside from that, I mean, I do think that India and China maybe have an opportunity to, try to sell their position to the rest of the world, because I think the U.S. pushes this, the EU pushes it a little bit, but I think most countries, even developed countries, are sort of resistant to it and are not that enthusiastic about it. So it may be that India and China could go to Australia and others and say, look, we are for better labor protections. We just don't think this should be in trade agreements. Why doesn't everybody just sign on to these ILO conventions? So, I mean, maybe that's the counter strategy, is to try to sort of like going back to the TRIPS and non-violation, sort of organize a coalition to say, we think there should be a different approach to this. We understand the U.S. concerns, and we have those concerns ourselves, and we would like, we don't want labor to be treated badly, but we just don't think this trade agreement approach is the right one. So, that's sort of the political behind-the-scenes negotiation strategy that I can't speak to how easy that would be to pursue and whether it would work, but it's just off the top of my head, it seems like that's something that could possibly be done to sort of counter the U.S. approach, which is put enforceable labor and environment provisions in trade agreements, and every now and then try to enforce them.
Professor, the Trade Promotion Authority, it's become sort of a buzzword these days in the trade circle. For the benefit of our viewers, could you tell us what the Trade Promotion Authority is empowered to do, and what is currently happening with respect to the TPA in the US?
Yes. So you have to understand a little bit about the U.S. Political system. So we have Congress and we have the president, and so when the president is for the most part in charge of international affairs, so the president will go off and negotiate international agreements, including trade agreements with our trading partners. The problem is that, and this sort of the problem arose in the 1960s, the president would go negotiate an agreement and then bring it back to Congress to sign off on. The way our Congress works, there's this sort of complicated amendment process. When Congress has a piece of legislation, it doesn't just, you don't just take what comes in and then sign it. People can propose amendments. And so, they had this, trade, I think this was related to the GATT. They had this trade agreement came in, and U.S. had negotiated with all of our trading partners, and then Congress was like, well, no, actually, we're going to change it to this. And so for our trading partners, for U.S. trading partners, they think, well, this just doesn't work. we negotiated, we had this careful balance of provisions in here that we all agreed to, and now the U.S. is changing it because Congress has stepped in. So to deal with that, people came up with this procedure where Congress in advance authorizes the president to go negotiate under certain conditions. Like, we want to see this thing in a trade agreement and this thing, but not this thing. And then the president would bring back a trade agreement, put it in front of Congress, and Congress would agree that we're only going to vote yes or no on it. We're not going to amend it. It's just yes or no. That way, our trading partners know that they'll be able to get what they agreed to in the negotiation. So that's the basic trade promotion authority. It was originally called fast track, and some people still call it that. So that's how trade promotion authority works. That's why we have it. The current mess has been just getting, I mean, it's purely political. I mean, you've got two parties. You've got the Democrats and the Republicans, and you've got two branches of Congress. You have the Senate and the House. And putting those four things together, you've just had trouble getting agreement on a package for trade promotion authority and something else, which is called trade adjustment assistance, which is basically sort of money for workers who lose their jobs due to trade. So basically, the Republicans want trade promotion authority but don't like trade adjustment assistance. The Democrats are somewhat skeptical on trade promotion authority. They do like trade adjustment assistance. So in the Senate, they were able to get a coalition of Republicans and Democrats together to pass both trade promotion authority and trade adjustment assistance. In the House, they thought they had a way to get this, but the Democrats sort of said, no, we're not willing to go along with it. And so they haven't been able to pass the same legislation in both the House and the Senate. And that's required. I mean, basically, the House and Senate both have to agree on something before the president can sign it as legislation. So what's going on right now is this negotiation between Democrats and Republicans in the House and the Senate to get trade promotion authority passed either on its own or in combination with trade adjustment assistance. The Republicans would love to have just trade promotion authority on its own. The Democrats would only want it with trade adjustment assistance. But they can't get a majority in both to sign on to the same thing, and they're working behind the scenes to try to figure out a way to do it. They've got ideas to do it now. They've given themselves until July 30th to come up with I mean, they set some artificial deadline of July 30th to do it a certain way. But really, this is just a question of, in the next couple months, can these groups come together and pass a package of legislation that includes trade promotion authority, which then the idea is the president can then go to our trading partners and say, okay, we've got trade promotion authority. Now we will agree. Now we've committed to pass the final package that we negotiate. So please give us your best offer now, and we'll finalize it. So it would have been better probably to pass trade promotion authority 6 years ago and then start negotiating the TPP. We've done it sort of backwards in that the TPP is almost done, but we don't have trade promotion authority yet. So the idea is find a way to get trade promotion authority passed, finish up the TPP, and then within, I don't know, it's going to be a couple months or a few months of debate, but then take TPP back to Congress and have Congress vote on TPP. So I don't know, tell me if I missed something in there and if you want further clarification, but I think that's the basic story of the history of TPA and what's going on now with TPA in the U.S. Congress.
No, absolutely. And that sort of brings us to a more theoretical question also, that do free trade agreements actually hurt? And in that regard, how exaggerated do you think claims are that free trade agreements are going to hurt domestic economies and in the context that it's going to cause job losses?
It's hard to come up with definitive numbers on that. But I mean, I do acknowledge, and I would agree that, this is part of the point of trade, is that, more efficient producers are going to do better and less efficient ones might go out of business. So I think there will be job losses and there will be job gains. I think on balance, I don't know that trade agreements, really affect the number of jobs. I mean, I think it's more of a benefit for consumers and for the efficiency of an economy as a whole. So what do you do about people whose jobs are lost due to trade? Well, I don't know. I mean, to me, there's a more general question. What do you do about people whose jobs are lost due to anything, such as new technologies? And we do have, general programs for unemployment and unemployment insurance, benefits where you lose your job. It's not clear to me why that doesn't just cover this situation, why we need special benefits for people who lose their jobs due to trade. It was a political solution to a problem that people perceived. Now, I'm much more comfortable with the free market maybe than most people. So the idea that somebody lost their jobs due to trade doesn't bother me that much. What bothers me perhaps even more is that they had, everybody had to pay more for products because protectionism gave them this job in the first place. To me, the real harm is from protectionism, and free trade is sort of a solution to that. And it disrupts the status quo, and people will lose their job. I acknowledge that. It's not clear to me why the general welfare programs aren't sufficient. So, but in terms of precise numbers, I mean, it is hard because you can see a specific factory maybe has closed or has moved to a different country due to a trade agreement. I have never seen a good quantification from it. I mean, it feels to me like the people who express concerns about it are exaggerating a bit. But I haven't done the calculations myself to say, all right, this is the actual number of jobs that are lost due to trade agreements. My focus has more been on here are the broader benefits to society, to economies, to international relations, and the idea that some producer moved its factory to a better place to produce it. It's not something that's that worrying to me, so that's why I haven't spent much time sort of sorting out the specifics of it.
Professor, I'm moving on to my final question, and this is with regard to the environmental goods agreement.
Okay.
What significance do you attach to an agreement of this nature? Do you feel that this is going to actually close the gap between trade and environment and complement the efforts being made currently to curtail the ill effects of climate change?
In general, I prefer just sort of broader trade liberalization than focusing on a specific sector. But I don't really object if somebody's got a specific sector that they think is important, like information technology, the environment. If you want to eliminate all the tariffs on that, I think that's great. I do think politically it should make environmentalists a little bit happy at least. I mean, I know they still have objections to various parts of trade agreements, but this seems like a benefit. On the other hand, there are a fair number of environmentalists who seem to just be flat out protectionist, and they seem to think, for reasons that I just can't fathom, that the environment is better off when you protect local producers of environmental goods, and I'm baffled by it. But I mean, you see in solar and wind these local content requirements, like we're going to give these subsidies for the environment, but only for locally made products, and it just doesn't make any sense to me. And I try to engage with them and figure out what's going on in their head and how they're seeing the world this way, but I have not got an answer. So it may be that the environmentalists you're trying to reach aren't gonna buy into this as a solution to anything. But I think there's a split there. I think there are some environmentalists who see the benefits of free trade environmental goods, but there are others who, for reasons that I can't fathom, just think that Ontario, Canada, for example, should have its own production of solar panels, which just doesn't make any sense to me. Buy the cheap ones from China. And that actually brings up another point, which is that a problem I've written about in relation to this agreement is that they're only talking about ordinary tariffs. What we've seen a lot of in environmental goods is anti-dumping and countervailing duties on imports of these products. And these tariffs can be really high. I mean, an average tariff might be 5 or 10%. Here you're getting like 100 or 200%. It seems to me if you have an environmental goods agreement that doesn't deal with the problem of trade remedies like anti-dumping and countervailing duties, you have a huge gap here. Now, I recognize that trade remedies are really sensitive and nobody wants to touch them, but it just seems to me if you really wanted to have a free trade and environmental goods agreement, you have to deal with trade remedies. And you have to say, not only are we going to eliminate all duties, we're going to eliminate all anti-dumping duties, but they're not even talking about that. So I've written it. I would love to see them do it, but I think that's it's not going to go in that direction. It's too sensitive of an issue.
Professor, thank you so much for joining us for this interview and sharing your thoughts on these very, very important issues. I'm sure that it's going to benefit our viewers in some way.
No problem. Yeah, thanks very much for having me. Great questions. I enjoyed the discussion.
Thank you.
Thanks.